Appeal has ruled that banks can be held jointly responsible with dealerships when financed vehicles are defective, misrepresented or stolen. The ruling is seen as a game changer for consumers. But to give us a little bit more details of what this really means, for those of us that want to buy cars, we are joined by Trudy Brookman, who is, of course, a consumer law expert. Trudy, a good morning to you, a happy new year, and thank you so much for joining us. I do want to start with the significance of this ruling by the Supreme Court of Appeal. As we start the year, you've got those that set their New Year's resolutions, and they've got their eye on a certain car and what they need to be thinking of as they consider what this ruling means for them.
Now, lady, normally I would recommend to a consumer who can afford to buy a car cash to buy it cash. But subsequent to this ruling, I think the game has changed, as you say, and it is certainly worthwhile for all of us who can afford, even if you can afford to buy a car cash, to take out finance for a proportion. It can be a really small proportion of the vehicle cost. So do take out finance. It mustn't be a personal loan. It must be traditional car finance. And then you know that you have recourse against the bank in addition to the dealership if something goes wrong with that particular vehicle that you have in mind. So I recommend financing vehicles and other assets. This judgment applies not only to cars, but also to any financed asset where the bank retains ownership until you've paid the final installment. And the benefit of it is beautiful because you can claim against the bank even after your finance has been paid off. So going forward, any type of claim that you have under the Consumer Protection Act, that 6-month claim where you can return the vehicle or the other asset and get your money back or get a replacement, that applies. But any common law claim as well, and the claim for damages for any minor defects, that you can take to the bank as well. And that applies, of course, any damage that's caused by a defect in the vehicle and other financed asset. I'm thinking of a car accident, even injuries, disability claims, etc., flowing from an accident being caused by a defect in an asset which has been financed. Consumers can claim that from the banks as well now if the asset was financed or the vehicle.
Yeah, so I mean, this is quite, a far-reaching sort of ruling, and you make that quite clear. I want to sit with the timeframes, though, a little bit, though, because what you talk about is you're able to claim even after the bank has been paid off that finance that the consumer may owe. But at what point must the issues with the vehicle or asset be picked up? So at what point do you need to make that assessment and ensure that you go back to speak to your financier about them?
Of course, it has to happen within a reasonable time. You can't see that there's an issue and then a year or two later you raise that with the bank. You have to respond immediately. And what I would recommend, because this is also brand new, that initially, as soon as you pick up an issue, speak to a consumer lawyer who can advise you in more detail. But for the first 6 months after you have received delivery of the financed asset, you have a right in terms of the Consumer Protection Act, if there's a minor defect, to get it repaired at the expense of the bank or the dealership that you purchased it from. And then if it's a major defect, you're entitled to either get your money back, to cancel, return the vehicle or the other asset and get your money back from the bank, the full amount that you paid in terms of any deposit and installments up to then, or to get a replacement of the same but without the defect. Yeah. So that's the 6-month right. And then for the rest of the duration of the lifetime of that asset, you can claim for any damage caused by a defect or a hazard in the financed asset or the vehicle. You must just make that claim within 3 years of the damage becoming evident.
Yeah. Do you have any sort of platforms or resources that we can make use of? Because obviously we've been talking about this ruling for a few weeks now in the country, many of us really wanting to understand what it means and which dealerships it may apply to, and I think that needing to be a distinction that is made quite clearly. Perhaps some platforms that South Africans can go to make use of that can help us clarify what this ruling actually means for them.
Okay. There's been a lot of interest in the press, so there's been analysis by a whole lot of personal finance journalists, and you would be able to find all of that online. Also, take a look at my website. Our firm's website is www.broekman.co.za, and Broekman is spelled BROEKMANN. .co.za. You will also find some analysis. There's a lot on LinkedIn, and there's been comment by the Consumer Goods and Services Ombud. Of course, you can always approach the usual bodies. I don't have a huge amount of trust in the motor industry ombud, so I probably wouldn't recommend that. But you can speak to the National Consumer Commission, the National Consumer Tribunal. All of these bodies are well aware of the judgment and are processing what all of the implications are for consumers and would be able to advise. But certainly speak to a consumer attorney.
Yeah, that really helps us to start planning and ensuring that as we fulfill those New Year's resolutions, we've got our protections in place. So Trudy Broekman there, a consumer law expert, is speaking to us. Right, some international news now. So analysts are expecting the political battle